You see, under the normal civil procedure, if the prosecution closes its case, and that may be the plaintiffs, that's what I'm using prosecution in the civil sense, but the plaintiffs.
My lords, with the greatest respect, yes, let's just stick to what we're familiar with. If you say prosecution in the civil...
Okay, so if the plaintiff closes his case, and the defendant realizes that the case the plaintiff has made has no substance or does not establish the reliefs he is claiming, and there will be no need for him to testify, he can tell the court that he will not testify, and then he will be put to his election. Whether, if the court rules in respect of his application, he will still testify or he will not testify.
My Lord,
that is the procedure.
My Lord, with the greatest respect, that is not the procedure under our rules. With the greatest respect, that procedure may apply under the English civil procedure rules, but it does not apply under our rules. And with the greatest respect, if I'm wrong in that, I would stand to be corrected. Which rule under our rules has that provision?
It's a settled practice.
My Lord,
we adopt. So are you saying that
my Lord,
a party cannot say that I will not testify, judge the case according to the evidence you have?
My lords,
because you cannot compel anybody to testify.
My lords, with the greatest respect, with the greatest
order in court, please.
With the greatest respect, I wish to take it a step at a time. If your lordship is referring to a submission of no case at the end of testimony, if that's what your lordship is adverting to, my respectful submission is that, one, under English common law, it is in fact not available in a trial which is not before the jury. Under common law, the authorities are clear that that process that your lordship just described is not available. And I am prepared to cite some authorities in the common law which make that clear, including a well-known case of Alexander and Racine. But, my Lord, before coming to that, I just wish to clarify that the common law position is very clear. Where there is a jury, it is open under the common law. Where there's a jury, it is open for When there's a jury, it is open for the plaintiff to say, indeed, that I don't want the matter to go before the jury. I'm ending at the point of the trial judge. But the common law position that has been clearly stated in the English Court of Appeal is that where there is only a judge and not a jury, that procedure is unacceptable. And there's a very clear reason given for it in the authorities, which I'll come to. But, my Lord, I want to...
Tsatsu Tsikata, I want to understand something. Are you suggesting that a party can be compelled to give evidence?
My Lord, that is not what I'm suggesting. I'm just suggesting that Order 36, Rule 3, applies in terms of the precondition that is put there. In terms of the precondition, it says where the defendant elects not to adduce evidence, then whether or not the defendant, and I'm saying respectfully that in this case, the first respondent elected to give evidence and notify the court as such. The first defendant elected to give evidence, notify the court as such, and on that basis, the court made an order for a witness statement to be provided.
Mr. Tsikata, you are aware that at case management stage, nobody knows the evidence that the others bring. It is after case management audits that the testimonies come in. Is that not it?
Very clear. I mean that's a matter of chronological necessity, because that is a chronological necessity. A case management happens before witnesses are called to testify, so there can't be any doubts about that. I'm referring to the fact that under Order 36.3, which counsel for the first defendant is seeking to come under. And my lords, this is also different from the submission of no case under the common law.
Excuse me, Order 36 for sub-rules 2 and 3 together. It says, subject to sub-rules, the plaintiff shall begin by opening the plaintiff's case. Then 2, where the defendant elects not to adduce 3, where the defendant elects not to adduce evidence. It presupposes that the plaintiff has finished his case. That is my understanding. I stand to correct it.
My lord, respectfully, that cannot. Respectfully, that cannot be the case. Because my lord, Order 36.4.3, and respectfully, as I said, those rules predated CI 87 on case management. CI 87 introduces case management on the basis of which your lordships have proceeded and given orders. And respectfully, I'm submitting that under the terms of CI 47 Order 36 Rule 3, where the defendant elects not to adduce evidence is a precondition for that. And in this case, the defendant at the case management stage represented that they would adduce evidence, and therefore that precondition does not exist. And the defendant made those representations to the court and to the court in a manner which led your lordships to determine.
Mr. Tsikata, may I seek clarification?
Yes, my lord.
Are you suggesting that under the case management regime, a defendant who indicates to the court before evidence is taken that I will call 1 or 2 witnesses in this matter, then after the plaintiff has given evidence, the defendant says, I don't think I need to call any evidence. Determine the matter on the basis of what the plaintiff has brought. Cannot do so?
Yes, my lord, I'm saying that he cannot do so where the court, on the basis of their representation, has ordered witness statements to be submitted. Because where he does that, he has elected other than what is provided for in Order 36.4.3. Where he makes that election at the case management stage, and the court has made an order appropriately.
Mr. Tsikata, you realize that Order 36 Rule 4 is only regulating order of speeches.
My lord, I didn't quite.
Order 36 Rule 4.
Yes, that's the
it's
next.
only regulating the order of speeches. That's all that the rule is seeking to do. But Atra.
Yes, but my lord.
But how can the law state that a party compel a party to give evidence by all means?
No, my lords, respectfully, if you say that the order of speeches is all that.
Yes, order of speeches.
Yes, my lords, that's a head note, and your lordship knows very well that the head note does not settle the interpretation of the provisions. I mean, Bernard Mona's case is a classic instance where the head note was shown to be completely different. And in fact, if we were only dealing with order of speeches, then my learned friend is completely out of court, because if that provision is only to do with order of speeches, then he cannot, on the basis of that, be asking your lordships to do or be telling the court what he told the court. If it's just order of speeches, then it will be interpreted as such. So it cannot be just order of speeches.
These proceedings are...
I'm sorry.
of Order 36 deals with proceedings at trial.
Yes, but Order 36.4, as His Lordship pointed out, is order of speeches. That's what Your Lordship pointed out to me, and I agree. It says order of speeches. And I'm saying that the head note cannot limit the terms of that order, respectfully, because in fact, if your position were to be accepted, respectfully, then you should throw him out of court completely, because we are not yet at the point of order of speeches. We are not yet at that point. So if all that 36 Rule 4.3 is dealing with is order of speeches, then all he said is irrelevant, because we're not yet at order of speeches. But the reality of the matter is that head note cannot limit the terms of Order 36 Rule 3. I believe that.
Mr. Tsikata, isn't compelling someone to testify a human rights question?
Also, my lords, I'm sorry. My lords, this is new territory. I mean, I have to think about it because frankly,
because nobody can compel a party to testify.
My lords, frankly, I have to give considerable thought. In fact, yes, I have to give considerable thought to what you're saying, that you're not...
as I'm sitting here, I'm reviewing this whole thing.
Yes.
I mean, nobody can compel a party to testify.
My lord...
That's a very basic rule.
My lady, as I said, I mean, your ladyship has been part of a ruling in this court which said the right to vote is part of the directive principles of state policy.
Mr. Tsikata, please, may I have your attention?
Yes.
Please, none of us, at least those on the bench, none of us anticipated this step.
Exactly.
So please come, both of you come and address us on this point tomorrow. Then you will give a ruling on it and then proceed accordingly.
My lords, I was actually going to make a similar submission because it is my respectful submission that for an application of this nature under Order 19, it should be made in terms of a motion paper and a supporting affidavit so that we can respond appropriately. No. Because, my lord, that application that is being made...
Please, with all respect, please, there's nothing factual about this application. Yes. Let's take it. If he comes tomorrow to raise this legal issue, you have the opportunity to reply. So please, just prepare.
Very well.
And bear with us tomorrow.
Very well. Very well.
Yes. Please, we want to know your position because you have also filed a witness statement.
Yes. My lords, we do not intend to call any witness.
Okay, then you prepare.
And my lord, let me complete. Order. We do not intend to call any witness because in our view, they have not satisfied the burden of proof. So we can't be forced to call any witness.
Please, we don't want lengthy answers. Please, what we want you to do is to prepare, come and address us on it tomorrow.